The theme of today's panel is talking about mental health or discourse and disease. And I'm going to talk about that today in the context of HIV and criminalization of HIV transmission and exposure in particular. We all know that the HIV/AIDS epidemic has generated a lot of talk. And it's also generated a lot of talk about how we talk. So, for example, we don't talk about AIDS victims anymore. We talk about people living with HIV. You hear falling into disfavor the term prostitution. Instead, we prefer sex work. Part of the reason for that, of course, is the HIV/AIDS and human rights movement. In the early 1990s, Jonathan Mann, who was then, the late Jonathan Mann, who was head of the World Health Organization's Global AIDS Program, remarked that no matter how HIV came into a community, it quickly became evident that it was society's most vulnerable, society's most discriminated against. In short, those who were most likely to fall on the short end of the human rights stick, who would tend most often to be affected and to be most affected by HIV. This continues to be the case today. So, for example, if you look at the fastest growing groups of people living with HIV, you'll note that, for example, in sub-Saharan Africa, it's women who are the fastest growing group. In particular, married women. In particular, married women with much older husbands. You start to see the picture that's being painted. And human rights discourse, as a consequence of all this, and also as a consequence of the very much the early activism in North America, which came from the gay community. Part of the consequence is that human rights discourse is taking up more and more space at, for example, the international AIDS conferences. So much so that some medical researchers have told me that they won't spend their time at the big AIDS conferences anymore. Instead, they'd much rather go to the retrovirus and opportunistic infections conference, which, for the record, for those of you who might know, is taking place here in Montreal this week, where at least the surface aspect doesn't seem so much to be there. For all of their concern that they might have about the circus, though, one interesting thing is that the medical profession and also public health officials very much understand the discourse of human rights when it comes to HIV/AIDS. Today I'm going to talk about one place where the health and human rights movement has had less impact. And this is, you may be surprised to know, the area of the criminal law. And what I wanted to do was to talk a little bit about the way a public health nurse or a public health official might look at some of the complexities surrounding disclosure of HIV/AIDS and compare that to the way in which a criminal lawyer might look at those complexities. And part of the reason why I'm doing that is because I'm trying to underscore the importance of having conferences like this one and to talk a little bit about the relationship between those two orders and why that relationship is important. And as others have done during these panels, I'm going to start with a story. And this is a story, I chose a local story, of a woman named DC, we don't know her name, who was diagnosed HIV positive in 1991. Well, starting in about 2000, she began a relationship with a man named JLP. This relationship was not an easy one. In fact, during the relationship, DC was abused by JLC and even successfully brought assault charges against him during the course of the relationship. Anyway, soon after they started going out, DC went to her doctor's office and she asked her doctor to tell her what would happen if, say, for example, the first time they had sex, the condom might have broken. What would happen in that circumstance? And the doctor sat down with her and talked to her and said, okay, well, you should really tell him. And you should really use condoms every time. And the woman said, okay. And they continued their discussion about it. And by all accounts thereafter, the woman did, in fact, go back to the gentleman that she was dating and say, listen, I'm HIV positive, and they did continue to practice safe sex. The difficulty difficulty here came when, after the relationship ended, JLP then brought charges against her for having failed to disclose her HIV status to him the very first time they had sex. In court, he argued that, or the prosecution argued that there had been no condom used that very first time. She said there had been a condom used, and based on the testimony of the doctor that she had visited, the court concluded that probably there wasn't a condom used, otherwise why would she have asked in the way that she did about the broken condom, or the potentially broken condom, and the court didn't believe her that a condom had been used that first time. The reason why I tell this story is just so that we can get a bit of a sense of the way that different actors might view how this story should be understood. A public health worker would look at this story and think, okay, well, this is a relative success, right? Here it's true that DC's behavior might not always have been good behavior, but she went to her doctor and she received support from her doctor, and a public health professional might understand that the process of learning how to disclose your HIV status is not a simple one and is affected by all kinds of factors. In this case, certainly the power relationship between the two parties. Given the fact that he turned out to be apparently an abusive partner, you can understand that it might have been difficult for her potentially to disclose in those circumstances. So it might, in a way, the public health sort of view of this would be, well, look at psychosocial aspects of disclosure, and it would say, well, learning to disclose is like learning to quit smoking. Learning to disclose is like learning to exercise. And together, DC and her doctor did very well. The criminal lawyer, on the other hand, sees things very differently. Under the criminal law, of course, this woman was guilty of an offense. In Canada and in most countries that have considered the issue, failing to disclose your HIV status and then going on to have unprotected sex is an offense. Whatever she may have done after the first week of the relationship would be, in the criminal law's view, irrelevant. If she didn't use that first condom that first time, she was guilty. It doesn't matter if the likelihood of transmission was somewhat lower from women to men than it would be from men to women. And power issues in a relationship are not really relevant, at least not where there's no defense, for example, of self-defense, where she didn't feel that that there was a risk of imminent harm, for example. There's no battered wife syndrome here that was alleged. So whatever complex human rights issues might have led to her vulnerability in the first place, they're not a concern of the criminal law when it comes to the question of whether she should or could disclose. Now, the upshot here is that in part because of the sort of structure of the criminal law and the sorts of factors that the criminal law is able to take into account, we find that in fact, public health actors have had in a lot of ways, much more profound engagement with some of the basic fundamental human rights drivers of the epidemic than have some of the major actors in the criminal justice system. That might seem a little strange because, of course, not having spent any time in the Faculty of Medicine, I imagine that we've got more courses with human rights in the name in the law faculty than you have here. Nonetheless, of course, though, I recognize that the Faculty of Medicine does engage quite profoundly, but there's something interesting about the fact that the human rights lessons that might come to the criminal justice system would end up having to come, or might end up having to come in some way through the public health system's understanding of what the human rights